The police department is the complainant, and the Commonwealth attorney is the plaintiff.
Okay. So you tried to get in touch with both of them to see if either one of these parties had any facts, evidence that they were going to bring into the case. We were trying to get discovery. You wanted to know because, like I said, they basically asked you, why do you need this, right?
Yeah, and they said that they in cases like this, they don't allow the defendant to have any kind of written form, and also the prosecutor says that they only give evidence the day of the trial.
Okay. And like I said, so 99.9%, what I'm saying is 99% of the people here in Virginia would just accept that and say, oh, okay, that's the way it's done, and I guess we're going to find out when we get to the trial. So how did I tell you? I was like, okay, that's a great, lovely answer they gave you. I said, now, how do you explain it to them why you need the case file?
Well,
in case somebody else runs into this problem, I'm trying to show people what's the next thing to do. What did I tell you to do?
I told them that I needed to see the evidence in order to prepare a proper defense and also to obtain competent counsel.
That's exactly it.
And also I said I will not intercourse in a trial by ambush.
Yeah. So this is what I'm trying to say to these people is what if you get stonewalled by these pat answers that these people give you, it's like, well, we don't do this. We don't give evidence, we don't give facts, we don't give a copy of the case file to the defendants until the day of the trial. You just say, well, wait a second, how am I to obtain competent legal counsel unless they know how to send a retaining fee? So he doesn't know if the domestic violence was like O.J. Simpson, where his wife's head was actually decapitated, or if it was a lamp and somebody got a boo-boo on his arm. So he's like, how, like the O.J. Simpson, domestic violence case lasted 1.5 years. But most domestic violence cases last 20 minutes, if that long. So, but to hire competent counsel, he needs to know what he's getting into. He needs to know how long this has been going on, how many past incidents are there. He needs to know what you folks are going to present to the court so he could set a fee. He said, see, this is all I'm showing you folks. I'm just showing you folks. I'm not saying go buy a lawyer. I'm just saying when you get stonewalled, this is some of the nonsense that I'm saying that you could actually use to either delay the trial or to actually get the file ordered, from the court, from the guy in the black robe. He says, look, they turned their case, their claim, over to I, the guy in the black robe. I now have control and have jurisdiction over the DHR's or the state's claim or the prosecuting attorney's claim. I've got control over it now. So now the plaintiff, he's the one who initiates the court. So it's his rules, it's his game, and he's the one who summons everybody to appear in that building. But once he turns his claim over to either the jury or over to the person in the black robe, then it becomes their court. They get to decide the fate of the parties. No, it's no longer in the hands of the person who initiated the suit. It's out of their hands. So that's what I try to, because some people are going to say, well, wait a second, Carl, you said the claimant is the court. You said yes, until he surrenders his claim to the court. He was the court. Now he surrendered over to the court. So he courted his claim. He brought his court into the building, and now he turned it over for them to judge it. Like American Idol, he came into the building. Now he's putting on his tap dance act, and now he's going to go up against another guy who's tap dancing or doing something else, and the jury or the judge is going to decide who's better, whose case is good. He's going to try a suit on before the jury, and who's going to win, who's going to lose. And like I said, and once it's determined, you can't. Like I said, thank God for the Seventh Amendment, so I don't have to explain it to you people. Once the jury says up or down, there's no court in the United States that could retry the verdict, retry the hearing, the case. They can't retry it. You can't do it twice. It's done. You just move on with your life. It's just like a duel. You shot, you're dead, you ain't coming back. Just accept the fact you're in the ground and it's dead. And it's discharged. There's no more life to this thing. So this is very simple. That all we were trying to do was try to get the copy of the case file. Because honestly, these people are so freaking lazy nowadays, They don't even prepare a case file anymore when it comes to any kind of like domestic violence or children and stuff like that. They're so freaking lazy because they figure, you know what, you're either going to go buy a lawyer or they're going to have a court-appointed one. And a court-appointed one is just going to throw you under the bus and say, oh, don't worry about the facts and evidence. Look, they're just going to give you 6 months in parenting classes or 3 months in anger management. You know what, just do your classes, and, in 2 years, if you know more domestic violence charges against you, they'll expunge the record. And people just say, okay, fine. But this lady, Tyra, is not going to let them get away that easy. She actually wants to see how they're going to move their claim into the court. So go ahead, Tyra, pick it up from where you said that you wanted competent counsel.
Right. Okay, so after the letter, I got the letter back on Friday from the Commonwealth attorney responding to what I told her I remembered about the conversation.
Well, what you did is you wrote to her. You didn't speak to her. You put it in writing.
No.
You left the note.
I put it in writing.
And you left the note on her desk, right, or something like that?
I gave it to the secretary and had him timestamp a copy of mine.
Right. So see, folks, even though she told the people, you spoke to the people, spoke to secretaries, or spoke to the police department, or whoever was the dispatch lady at the desk at the police department, she still put it in writing. Very simple. You just basically said that you require discovery, and the lady tried to tell you, well, we call it disclosure, not discovery, and she told you to go follow the rules, and then you came back and you called me and said, now what do we do, Carl? And then
So I put in what I call a notice to schedule and a notice to order full disclosure, and I said on the notice to order full disclosure, I put in brackets compared to motion for discovery.